Good afternoon. Welcome. Please keep eating. My name is Peter Rofus. I'm a member of the faculty and Associate Dean for Academic Affairs. Thank you all for taking the time to join us today. 220 years ago, delegates to the Constitutional Convention in Philadelphia placed their signatures on one of the most enduring and influential documents in history, the Constitution of the United States. On September 17, 1787, 55 delegates to the convention conducted their final meeting at Independence Hall. One principal item of business occupied the agenda for that day, to sign the Constitution. And depending on the historical materials one trusts, either 39 or 40 of the delegates did so. But lots of work remained. In particular, the document needed eventually to make its way to the states for consideration, and many, not all, but many hoped ratification. And so pursuant to the resolutions adopted at the convention, the delegates proceeded to submit the document first to the Confederation Congress. That Congress, after 3 days of spirited debate, and by the way, that debate included a battle about whether the Constitution was itself the product of a convention that had exceeded the legal bounds of its mandate. But that Congress crafted a compromise that resulted in passing along the document without any endorsement to the states, kickstarting a process through which individual state conventions would gather over the next 2.5 years for the purpose of considering the wisdom of ratification. In short order, from December 1787 up through the next couple of months, 5 states, Delaware, Pennsylvania, New Jersey, Georgia, and Connecticut, ratified the document. Trouble then emerged in Massachusetts, where proponents ran into serious opposition. Again, a compromise was forged, one that produced a narrow margin of victory by virtue of a concession that, in the event the Constitution indeed became law, the new Congress would undertake promptly to consider amendments to it. Over the next few months, Maryland, South Carolina, New Hampshire, Virginia, and New York brought to 11 the number of states ratifying the Constitution. And not until a year later, after it became virtually a certainty that what we now call the Bill of Rights would be added to the original Constitution, only then did North Carolina and Rhode Island join the party. Now, this month represents the 3rd time that America's educational institutions are sharing in a nationwide effort to observe what is now called Constitution Day. This is because in 2004, members of Congress asserting that American students lack adequate knowledge of their national Constitution, Congress mandated that educational institutions receiving federal funding offer students a program devoted to the Constitution. In short, the simple but delightfully paradoxical truth is that we gather today to celebrate the freedoms we deeply cherish because our national government has passed a law directing us to do so. And so in the event you took your seat with the expectation of leaving prior to the conclusion of the program, allow me to inform you up front that federal agents whose principal task is to discourage you from doing so are stationed at the doors. 4 talented and accomplished folks whom I am proud to call colleagues have joined us as speakers for today. Each is going to deliver remarks devoted to a topic of his choosing that pertains to our national Constitution. After the last of the presentations, I will turn to you and invite your questions and comments. And assuming our panelists are forthcoming with some answers, and I do anticipate that will be the case, given the fact that, to my knowledge, none of them is scheduled to appear before the Senate Judiciary for confirmation anytime soon. After that, we will then adjourn. I am cognizant of the fact that many of you in the audience have 1 p.m. commitments, particularly a large group of 1Ls, and I'm going to do everything in my power as moderator to wind down the program so as to enable those of you who have 1 p.m. classes to make those classes in a timely manner. With that, allow me to pass the baton to Professor David Papke, whose remarks are entitled "The Constitution as an Icon of American Life." Professor Papke.
Thank you. Thank you. I suggested to Peter that I go first because I think I'll be approaching the Constitution a slightly different way than my fellow panelists. I'm going to be speaking about it in more general terms. I'm going to be using historical frame and cultural studies frame rather than legal argument and legal reasoning. And in particular, I'm going to speak about the United States Constitution as an icon. And this approach is unusual. I think we're more used to thinking of the Constitution as law, our supreme or fundamental law. And the Constitution does, in fact, set out the national governmental scheme of federalism, bicameralism, separation of powers. It also, through its amendments at least, articulates our rights. So there's more than enough here for a law course on the subject. In fact, I've taught at 4 law schools over the years, and I've been kind of surprised at all 4 that the subject of constitutional law does not receive more attention than it does receive. In some courses in constitutional law, we have ample opportunity to contemplate the Constitution as a text as well as law, and it's quite a text. The Constitution has slightly over 5,000 words, not counting amendments, and the text is arranged into 7 articles in order of declining complexity and, I think, importance. It's a very workmanlike text, one without the flair of metaphors, tropes, rhetoric. When the novelist E.L. Doctorow, author of Ragtime, among other novels, contemplated the Constitution at the time of its bicentennial in 1987, he found the text soft-spoken. Quote, "The voice of the Constitution is a quiet voice. It does not rally us. It does not call on self-evident truths as does the Declaration of Independence. It does not arm itself with philosophy or political principle. It does not argue, explain, condemn, excuse, or justify. It is post-revolutionary." End of quote. Now I want to discuss the Constitution as neither law nor text, but rather as an icon of the civic faith. And you're probably most familiar with icons as items people use to worship in their religions, religious carvings or a crucifix perhaps. And icons, totems, and symbols of this sort provoke uncritical religious devotion. Believers can use them to reinforce their religious beliefs. I like to think of an icon as a door that opens onto the faith. You walk through it, and you can explore and revel in all that the faith entails. The Constitution, in my interpretation, is at least potentially an icon for the American civic faith. And this faith, I should make clear, is neither Protestantism nor Christianity. Indeed, it's not religion as traditionally understood, an institution with houses of worship and a clergy and dogma and so forth. Civic faith, as I'm using it, is instead a general system of American beliefs. In the case of the American civic faith, there have been shifts over time, of course, but I think the faith's major tenets would be liberty, democracy, self-enrichment, and the rule of law. In the past, I want to argue Americans could and did use the Constitution as icon to worship and glory in the American civic faith. The men who met for 3 months in Philadelphia in the summer of 1787 to draft the Constitution seem on some level to have realized that the document could become iconic. They decided to keep the process that produced the document to themselves. They called on anyone who took notes during the deliberation to turn those notes over to George Washington, the most honored member of the group. And they actually took an oath to lifelong secrecy regarding their deliberations. And oaths were serious matters in those days. The biggest potential problem seems to have been Ben Franklin, who had a reputation as a blabbermouth. But even Franklin promised that he would never, quote unquote, whisper a syllable, never would whisper a syllable to anyone else. And the framers, I think, seemed to realize the advantages to be gained if they enveloped the Constitution into something resembling religious mystery. And indeed, the Constitution got off to a roaring start. As Dean Rofus suggested, there were fierce debates in the various state assemblies about ratification. But whenever a state ratified, there were celebrations and parades and so forth. The parade in Philadelphia probably deserves the title most excessive. It included city officials, clergy of every denomination, units of light infantry and cavalry, cadre of the recognized trades, each dressed in distinctive working clothes and carrying a display related to their trade. There was a literal ship of state hauled on a wagon down the parade route. There was a float shaped like an eagle featuring a giant representation of the Constitution. That might have been enough, but the most discussed aspect of the parade was the so-called new roof float. It presented the Constitution as a roof-like structure, supported by 13 pillars and presumably sheltering the Republic. It was drawn by 10 white horses, ornamented with bright stars and crowned at the very top with the figure of plenty and the sprawling cornucopia. Newspapers and journals in the states that ratified began referring to the Constitution with awe and reverence. James Madison, who by some accounts, including his own, was the most influential participant in the debates on the Constitution, said in 1792 that the citizenry should, quote, approach the Constitution with holy zeal as our political scripture, end of quote. Some thought all of this touting and praising of the Constitution was a crock. Thomas Jefferson, for example, warned that treating the Constitution like, quote, an ark of the covenant too sacred to be touched was a mistaken step. But in general, Americans could not be deterred. 19th century school books spoke of the Constitution as divinely inspired, routinely involved the words glorious, revered, sacred. The Washington Benevolence Society, which was in some sense the 19th century evangelistic wing of the civic faith, distributed thousands and thousands of copies of the Constitution, free to the citizenry. Various entrepreneurs sold Constitution banners, wall hangings, and even handkerchiefs with all or part of the Constitution on them. Americans could and did frequently carry the Constitution with them in the 19th century. And if you couldn't read it, actually read it because you were illiterate, that didn't seem to really matter. Writing in the 1930s, the scholar Max Lerner said that people believed in a kind of word magic. What they wanted was a visible symbol, an icon, if you will, that they could hold dear. The 19th century political figure who was perhaps most invested in the notion of the Constitution was Daniel Webster. He forcefully argued various constitutional cases, served as a senator from New Hampshire under the Constitution, and for purposes at hand, fancied himself the defender of the Constitution. Webster even played a role in what is perhaps the 19th century's most morbid example of constitutional worship. He was with President William Henry Harrison at the time of the latter's death. Harrison was the great hero of the Battle of Tippecanoe, and he apparently shook hands for hours in the rain following his 1841 inauguration as president, and then retired. Harrison retired to what would literally become his deathbed. He only served 1 month as president before he died. And as Harrison died, at least according to Webster and 4 others who were present at the time, the last utterance from his lips expressed the fervent desire for the perpetuity of the Constitution and the preservation of its principles. So even for the dying, the Constitution as icon could objectify mythic tales of the civic faith. Abrupt and given time limits, obligatory fast forward. Do any of these attitudes live on into modern times? Is the Constitution still an icon in American life? Surely it remains important as law and as text, and I think my fellow panelists will speak to it primarily in those ways. However, I'm hard-pressed to come up with significant and powerful invocations of the Constitution as an icon in the last 25 years or so. Perhaps you know of some that have eluded me, but the ones I thought of are a little bit disheartening. If you go back to the Watergate era of the early 1980s, for example, there's the woolly figure of Senator Sam Erwin, a Democrat from North Carolina. He chaired the Senate Watergate Committee and is at least in part responsible for driving Richard Nixon from the presidency. And in the hearings, on the cover of his autobiography, and in general, he cast himself as, quote, the champion of the Constitution, our sacred covenant, end of quote. However, it didn't help that he kept dozing off during the Watergate hearings, and I don't think it could be said that he led any inspired renewal of reverence for the Constitution. A bit closer to the present, we have the bicentennial of the Constitution, 1987. It featured parades and fireworks, too. I remember watching the fireworks over the New York City harbor from a friend's law office in a Wall Street law firm. But there were problems with the bicentennial. Former Chief Justice Warren Burger was the chairman of the Bicentennial Commission, and he and Justice Thurgood Marshall got into a large public argument about whether the Constitution was great. Marshall thought that the original Constitution was seriously flawed, and the document became admirable only after amendments ended slavery and granted women the vote. So this debate between Burger and Marshall, public debate no less, is hardly the stuff of iconography. Still closer to the present, there's the American Constitution Society. At first glance, the organization might look like the equivalent of the Washington Benevolent Society, the 19th century. And in fact, both organizations distribute now free small replicas of the Constitution. You can use them to worship in the civic faith. But on further reflection, the American Constitution Society is more partisan, albeit admirable, goal. I'm the faculty advisor for the local chapter, so I'm not here to bury the organization. But the American Constitution Society aims to be a progressive foil to the Federalist Society, the ubiquitous, powerful, and frequently annoying legal front for neoconservatism. The Constitution is a symbol for the American Constitution Society, and it uses it to fight the good fight politically. So I'm afraid I'm left to conclude that the Constitution is not the icon it once was. I don't think, though, it's because the Constitution is weak or flawed. I think the problem is something bigger, and it has to do with the civic faith generally. We live in a postmodern society in which many no longer have faith. Liberty, democracy, self-improvement, self-enrichment, the rule of law, those are not things that are frequently shouted to the rooftops anymore. One exception might be self-enrichment. These notions were powerful notions of a society in the throes of modernization, but our nation is past the point of being modern. Scholars have written of the rise of identity politics in our present. Whatever one might think of those politics, it must be admitted that they lack the grand synthesizing political visions of earlier ideologies. They are in some sense depoliticized. Then too, there is the tremendous self-absorption of the present, a pattern among the American middle and upper classes that led Christopher Lasch to dub our era the age of narcissism. These aspects of postmodern society are not easily coordinated with the traditional civic faith, in my interpretation. Now, this gathering is designed to honor the Constitution, so I don't want to seem like Steve Martin's George Banks character in the remake of the movie Father of the Bride. If you know the movie, it looks like nobody does. George Banks is always whining and complaining about his daughter's wedding and the plans for the wedding and so forth. People had a belly full of him. Finally, a couple of them get together and sing, "Everybody needs a pooper. That's why we invited you, George Banks." You know, well, so I don't want to be George Papke, is what I'm saying. But my concluding point goes back to the sense of how an icon works that I mentioned at the outset. I suggested that an icon was a door that opened onto a room where you could partake in the wonders of the faith. Well, what if we opened the constitutional icon and entered the room of the civic faith only to find the room was empty? Thank you.
Thank you, Professor Papke. If there is a way to make a logical order out of these four presentations, and I'm not sure there is, but if there is, it seems to me that Professor Eidelman's talk on American Indians should come next. Professor Eidelman.
Well, if you're expecting a song out of me, it's not going to happen. The name of this talk, or we'll talk about, is American Indians and the Constitution. A lot of it's going to be general things you may or may not know about their constitutional status in the United States. And then I'd like to end with some questions that are plaguing the courts and scholars, and some unanswered questions about Indians and the Constitution. There are in the United States at present well over 500 federally recognized Indian tribes. There are all sorts of other groups that would like recognition but don't have it. There is in this state at least one. In this state we have 11 federally recognized tribes. Some of them are from here, in their view, from time immemorial. Others were displaced from other parts of the country and put within what is now Wisconsin. If you look at the Constitution, there's not a lot of terminology relating to Indians. One thing we clearly see in the Commerce Clause, or Commerce Clauses, in Article 1, Section 8, Congress shall have power to regulate commerce with foreign nations, among the several states, and with the Indian tribes. A fair inference under that set of clauses, or clause, is that tribes are somehow comparable in a meaningful way to foreign nations and states, domestic states, foreign nations, that they bear sufficient indicia of sovereignty that they ought to be put in there. That's not the only interpretation that you could take. These are just things that Congress deals with, and they involve commerce. But the court has adopted that interpretation, certainly the tribes have, that this is a constitutional embodiment, embracing of their sovereignty. So one characteristic of tribes is sovereignty, some sort of sovereignty. Sovereignty is no longer a full package. You can have like property rights. You can have certain aspects and not others. We know that following a war, for example, countries will undergo various stages. At some point, they're not really sovereign at all because the conqueror or victor might have complete control, but in 10 years they may be of a limited sovereignty, and eventually they may regain their full sovereignty. Tribes are also, in a sense, extra-constitutional. Constitution embodies them, but they are not bound by the Constitution, with maybe a few exceptions. 13th Amendment would be a possibility. But the Bill of Rights, for example, does not bind tribal governments. Instead, what Congress has had to do is pass the Indian Civil Rights Act. It's a 1968 statute which contains various statutory analogs to several of the Bill of Rights provisions, as well as other provisions you'd find in the original or amended Constitution. Some are missing. There's no establishment prohibition, establishment of religion. But most of them are there, and if you read through, say, I've read this before, it's a certain deja vu, and many of them are lifted out. Tribal members are not citizens and not included for apportionment from the perspective of the Constitution. Under the Constitution, tribal members are not citizens. They're citizens because Congress in 1924 passed a statute conferring citizenship. Supreme Court has never gone back and said the statute was unnecessary or it's no longer necessary. That question is not answered because the statute was passed and it functions fairly well. They are not included for apportionment under the 14th Amendment, Section 2. So under the 14th Amendment, Sections 1 and 2, citizenship and apportionment, Indians appear not to be included. In fact, in Section 1 specifically, or in Section 2, it specifically talks about Indians. So in our Constitution, Indians have a sovereign status, but a separate status. And just one other characteristic, and it flows perhaps more from constitutional history or the history under the Constitution through cases and so forth. Tribal lands, particularly if they're federally embodied, held in trust by the federal government, are to a certain extent extraterritorial to the states, the one or more states which include them. They are largely beyond state jurisdiction, absent a federal statute conferring such jurisdiction. There are some doctrines about exigent circumstances and some natural resource doctrines. But had Congress not conferred upon the state of Wisconsin criminal, prosecutorial and other jurisdiction over what is now 10 of the 11 tribes, Wisconsin would not have it. And in fact, the Menominee Nation, criminal prosecutions of the Indians are in federal court. It's just a matter of congressional selection. Okay. What are some constitutional consequences of this status, or what are the consequences of this constitutional status? And just to talk about a few. Let's talk about power, first of all. Once you're designated a sovereign, your next question is, well, what powers and prerogatives of sovereignty do I possess? My sense is you start out with a full package and you work backwards. In some instances, it's a rather quick process back to a small, package of powers and prerogatives. But the way the Supreme Court has framed it is absent a cession of the power or prerogative by a tribe, giving up, an abrogation or elimination by Congress through statute, or an inconsistency between the possession of that power and the nature, the sovereign nature of tribes in a limited sense. The tribes possess the powers. Okay, so the presumption is in favor of possession. And by the way, John Marshall described tribes as domestic dependent nations. They're within the borders and they're dependent. The United States is the conquering, or the European nations are the conquering nations, and the status moves on to the United States. This is something that Britain necessarily conferred to the United States. This last category, what's inconsistent with the status of a domestic dependent sovereign? For one thing, tribes cannot prosecute non-Indians. So you could, if you'd like to, go to the Menominee Reservation this evening, and commit some crimes and see if that works. You will find yourself in Green Bay at the federal, or in some federal form of custody, rather than in tribal custody, because tribes can't prosecute non-Indians. If you want to go to the Oneida Reservation, commit the same crimes, you'll end up in state custody. You could probably have ended up in federal and state custody anyway, but the fact is you won't be subject to the tribe's criminal authority. Tribes can't declare war. They can't enter treaties with other nations, though many of these were supposedly taken away at the time of discovery and conquest. Tribal court prosecutions, convictions of Indians, right, not of non-Indians, usually don't give rise to any double jeopardy concern because they're a separate sovereign, right? State and federal prosecutions for roughly similar or identical crimes are by two different sovereigns. There's no double jeopardy. It has to be the same sovereign putting you in jeopardy of life or limb. And in theory, at least, you could be triply prosecuted, and there would be no triple jeopardy, double jeopardy. Depends how you want to view that. There would be no jeopardy of a constitutionally offensive nature. Equal protection. Congress has one of the titles of the U.S. Code reads Indians on the spine. If you read it that way, but reads Indians on the spine. Are Indians, at least in part, a racial, ethnic, ancestral group, or is it a racial, ethnic, or ancestral classification? And the answer is yes, by the tribe's own criteria for membership. But the Supreme Court has said it's really a political classification because the federal government is dealing with them as a sovereign. So this is an outgrowth of their status as a sovereign. So in many respects, there's an immunity on Congress's part from normal equal protection analysis because otherwise Title 25 would be subjected to strict scrutiny. Every time, and if you would like to put into Westlaw the term Indian into Title 25, I suspect Westlaw would tell you need to narrow your search, okay? So Title 25 would be in jeopardy. One of the lingering questions at this point, does a state have that immunity, if you'd like to call it that? Can states pass laws, as they do, dealing with Indians, when there's not that traditional historical sovereign-to-sovereign relationship? Another question, should the Bill of Rights provisions, Amendments 1 through 8, or at least some of them, apply directly to tribes? Congress has foreclosed consideration of that question as a practical matter. But incorporation of the Bill of Rights to the states through the 14th Amendment, and you all remember common law, you read your case books nightly, right? Incorporation was not an easy question. Some of the ratifiers or those who advocated for the 14th Amendment indicated their understanding that that's exactly what it was going to do, was to transfer or expand the application of the Bill of Rights to the states. Others had no such comprehension. And in fact, it took the court 60 or so, or 50 or so years to figure that out. If it were so self-evident, surely the court could have figured it out earlier. Is there some provision in the Constitution or some means of interpretation that despite the absence of the word state, or despite the absence of a 14th Amendment for tribes, is there some means by which tribes could be brought within the constitutional fold? So, and I'm ceding my time if I have any back to the presider, and I'm not singing a song. So that is a glimpse of the constitutional status and consequences of that status of American Indian tribes. They are embodied in the Constitution. It is subject to interpretation, but they are of a constitutionally elevated status, and something has to be done with that. And maybe in 50 or 100 years, we'll have a completely different doctrine. But that is where we are today, and a lot of people just don't know that. And my purpose here today is to let everyone know that little corner of the Constitution. So, okay, I'll pass it back to Peter. Thanks.
Thank you, Professor Eidelman. I suspect we will move to some of the more explosive constitutional issues of the day with our next two speakers. Professor Falone will be speaking about borders and the war on terror. Professor Falone.
Thank you very much. Normally I do have a song prepared, but in the interest of time I won't. Mr. Almari was a permanent resident alien living lawfully in Peoria, Illinois. He was taken into custody, held in military detention. This past June, the Fourth Circuit Court of Appeals held that the President's constitutional powers do not allow him to order the military to seize and detain indefinitely a foreigner lawfully present within our borders without criminal process. And that case will be decided by the Supreme Court this term, or at least argued in front of the Supreme Court this term. 4 months earlier than that decision of the Fourth Circuit, the Court of Appeals for the D.C. Circuit held that a foreigner without property or presence in this country has no constitutional rights under the Due Process Clause or otherwise. My contention is that these two opinions stand in stark contrast and represent distinct interpretations of the U.S. Constitution. At first blush, you would say, well, there is no contrast here. These are reconcilable. Both holdings could be read as consistent with the following basic premise. Foreigners within the presence of the United States, within our borders, are entitled to the benefits of the Constitution's protection, and foreigners outside of the United States borders can make no such claim. But any attempt to reduce the constitutional status of foreigners to a straightforward geographical proposition will ultimately collapse because that proposition rests on a legal fiction. The Supreme Court's jurisprudence has long exhibited a disregard for literal borders. Foreigners standing on Ellis Island were certainly present within literal U.S. territory, but the Supreme Court long ago adopted the fiction that they had not entered the United States and therefore could not appeal to the Constitution for any rights. On the other hand, foreigners who have entered the United States, whether lawfully or unlawfully, many miles into our border, are oftentimes said to possess different and lesser constitutional rights than citizens. Most recently, the Supreme Court deciding a case involving the U.S. military base at Guantanamo Bay, Cuba, located within a foreign sovereign nation, strongly suggested that the treatment of detainees housed at Guantanamo Bay must follow our country's constitutional norms. So, an individual's presence or absence within our borders has never been the sole determinant of the existence of constitutional rights. A constitution that claims to recognize the existence of basic individual rights should not condition the existence of those rights on an elastic and arbitrary concept of borders. Beyond the issue of borders, I think these two cases of the circuit courts force the federal government to face a long-simmering question of fundamental importance to the interpretation of the U.S. Constitution. Who are the people who can assert the protection of that document? And one byproduct of identifying the people is, of course, that the remainder of the population of the earth becomes outsiders. The primary purpose of the American Constitution is to protect the people in the enjoyment of their lives, and this protection takes two distinct forms. An individual can, in a sense, play offense with the text of the Constitution by seeking to assert the freedom to exercise identifiable rights described and contained in that document. But the Constitution also provides a second type of protection. The Constitution defines and limits the scope of governmental authority, that therefore allowing individuals to assert the existence of structural limitations on federal power. These structural limits are like chains that bind the federal government and keep it within defined boundaries. And an individual could play defense with the text by arguing that the government simply lacks the power to take certain actions, even in cases where the constitutional text does not identify a specific right that the government is accused of infringing. Now, it's uncontroversial to assert that the people enjoy the first kind of constitutional protection, and that outsiders cannot assert identifiable rights in the Bill of Rights. It's also uniformly accepted that the people can use the structural boundaries of the Constitution to play defense and argue the government lacks certain power. But the advocates for the detainees being held in the War of Terror argue that outsiders may also protect themselves defensively by asserting the existence of structural boundaries on government power. If the Constitution does not affirmatively grant power to the federal government, then the federal government may not exercise that power domestically. It may not exercise that power extraterritorially. It may not exercise that power against citizens. It may not exercise that power against non-citizens. And if this contention is correct, then the Constitution is borderless. We could resolve these questions in a simplistic fashion and simply retreat to the concept of literal borders, say the Constitution should only have full effect within our borders, it should have no effect outside our borders. Simplistic solutions have a surface attraction during complex times in our nation's history. But I think that this ignores the ambiguous nature of the Constitution itself. I think that what we see here is merely the latest iteration of an unresolved battle between two competing views of the Constitution that has persisted since 1789. And now the War on Terror is bringing this to a head. One view starts with the proposition that the federal government is the creation of the Constitution. It is an artificially created entity. It is incapable of possessing any power or authority that is not granted to it by our foundational government. Neither a citizen nor a non-citizen can be subjected to any exercise of power that is, in a sense, an ultra-virus act. You might think of this as the delegation view. An opposing theory of constitutional interpretation views the Constitution as a kind of contract between the government and members of a political community. Under this view, only members of the community who are parties to the contract can claim the benefits and protections of the Constitution. Individuals who are outsiders to the community, for example, a French national born and raised in France, never entering the United States, cannot claim to possess any of the rights or protections guaranteed by the Constitution. Not only would outsiders be precluded from claiming protections of the Bill of Rights, from claiming affirmative identifiable rights, but also outsiders would be precluded from asserting structural limits on the government's power. You can refer to this as the compact view of the Constitution. The War on Terror raises these issues because we have detainees in various categories. We have detainees being held in military detention within the U.S. We have detainees being held in detention outside the U.S. So the issue of borders comes into play. We have some detainees who are non-citizens. We have some detainees who are lawful permanent residents. We have some detainees who are citizens. So the issue of who is a member of our political community comes into play. The Bush administration's position has been to assert a governmental power to detain suspected terrorists and enemy combatants across the board, without regard to geography, without regard to resolving membership in the political community. And so as cases addressing the Bush administration policy work their way up through the circuit courts and reach the Supreme Court, finally we're going to have to resolve some of these ambiguities. My contention is that the framers of the Constitution intended to adopt a delegation view of the scope of federal authority, that the compact view was primarily justified in the rationale of the Dred Scott decision of the Supreme Court, which sought to define slaves and the descendants of slaves as outside the political community, that attempt to interject the compact view into our constitutional jurisprudence was rejected by the 14th Amendment, but that subsequent to the 14th Amendment, in a series of immigration cases, first dealing with the rights of foreigners outside our borders seeking to enter, then dealing with the rights of foreigners within our borders, slowly the compact view began to worm its way back into our constitutional jurisprudence, becoming more and more established in the immigration field. And then once the War on Terror presented the opportunity, this compact view has spilled over now into mainstream constitutional jurisprudence. I think that hopefully the Supreme Court will decide this conflict between the delegation view and the compact view in the war on terror cases. I think that the best view is that the federal government always lacks the capacity to exceed the powers granted to it under the U.S. Constitution, and this lack of capacity is not dependent on either the geographic location where the government conduct occurs or the citizenship of the individuals subjected to the government conduct. And I think we should recognize that to a significant degree, we have a borderless Constitution. Thank you.
Thank you, Professor Falone. Our final speaker, Professor Rick Essenberg, will likewise talk about contemporary developments, in particular, two recent controversial cases. His talk is entitled Speech Rights After Wisconsin Right to Life and Morse. Professor Essenberg.
You know, on this federally mandated day of observance, I was heartened to hear Professor Papke talk about the Constitution as an icon, as a thing to be celebrated, perhaps even worshipped. The iconic status of the Constitution really came home to me last night as my wife and I gathered to string lights on the Constitution Day tree. Yeah, you think I'm joking, but my wife has lights for just about every holiday imaginable. She missed Constitution Day this year, but she will not miss it next year. I wanted to talk a little bit about two cases decided the same day. Wisconsin Right to Life versus FEC, Morse versus Frederick. One, Wisconsin Right to Life, sustaining a First Amendment challenge to the application of an act of Congress. The other, Morse versus Frederick, rejecting a constitutional challenge to disciplinary action by local school officials. Let's talk about Wisconsin Right to Life first. This was an as-applied challenge to Section 203 of the Bipartisan Campaign Reform Act, more commonly known as McCain-Feingold. Section 203 essentially provided that no corporation or union could expend general treasury funds on an ad mentioning a candidate for federal office within the jurisdiction that the candidate was running within a specified blackout period before the federal election. This was an attempt to plug what had been deemed to be a deficiency in prior law, in which essentially these independent advertisements could only be regulated, that is they could only be limited to being paid for by regulated PAC money if they were if they either expressly advocated the election or defeat of a candidate or contained magic words of express advocacy like vote for X or vote against Y. This was an attempt, I think, by Congress to extend regulation to, what we've all seen now, these ads every election season, they're sepia-toned, grainy photographs of the candidate who is targeted, and, this voice comes on, and I am convinced that it is the same guy who narrates all these ads, and he says, call Senator Smith now and tell him to, whatever, stop taking a wide stance in men's rooms or whatever it is that, that he's supposed to not be doing. In FEC versus McConnell, or McConnell versus FEC, the Supreme Court 3 years earlier had upheld a facial challenge to Section 203. It had said that no, Section 203 is calculated to catch ads which are the functional equivalent of express advocacy, that Congress has a sufficiently compelling interest in regulating these ads because of fear of corruption and the distorting influence of legal entities that are sort of structured in a way to assume large amounts of capital. Wisconsin Right to Life was an as-applied challenge to the application of Section 203 to some ads that the Wisconsin Right to Life organization wanted to run, ironically, or perhaps not so ironically, during Senator Feingold's bid for re-election. The ads were sort of a sort of a moderate specimen of the genre. They were targeted at what Wisconsin Right to Life's concern that the Senate Democrats were filibustering President Bush's judicial nominations, and one of the ads in particular, had a couple coming forward to the altar, and the pastor says, to be married, and the pastor says, who gives this woman to be married to this man? And the father of the bride turns and says, well, I would. But first, I'd like to share some tips about how to properly hang drywall. And then he goes on, and the ad says, some decisions have to be made. Some senators are holding up these judicial nominations. Call Senators Feingold and Cole and tell them you want to vote. Didn't say what position Senator Feingold and Cole were taking, although there was a little thing in the ad that linked to a website in which you could go to, in which they made quite clear what their positions were and what they thought of their positions. So the question is, could Section 203 be constitutionally applied to this particular ad? A majority of the Supreme Court, 5-4, held that it could not be. Chief Justice Roberts, joined by Justices Alito and Kennedy, essentially held that rejected the FEC's position that McConnell had basically decided that the test for an as-applied challenge was whether or not an ad had the intent and effect of advocating for a candidate, and instead essentially substituted a test which says that the ad is an issue ad unless it is susceptible of no interpretation other than advocacy for or against a candidate for federal office. Justice Scalia and Thomas joined in the results, but said that they would find Section 203 facially unconstitutional, as they would have in McConnell. The dissent obviously took a different view. They said if an ad could be interpreted as advocacy for a candidate, then Section 203 could constitutionally be applied to it. Chief Justice Roberts' opinion felt that that provided insufficient clarity and an insufficiently broad safe harbor for protected speech. And if you read the opinion, there's a lot of language in there about how the tie goes to the speaker, and we have to err on the side of protecting speech, and therefore we're going to adopt this construction, this test, and we're going to apply it essentially by looking at the four corners of the ad. The Roberts opinion does not exclude the possibility that context would be considered, but the emphasis really is let's look at the language of the ad and let's see where whether or not it has any, we can possibly interpret it as an issue ad. If we can do that, we'll give it the benefit of the doubt, and it falls outside of the Section 203's constitutionally permissible scope. Critics of the Wisconsin Right to Life decision have said that it essentially overruled McConnell, and I think in the sense of did the Chief Justice distinguish McConnell in an intellectually satisfying way, the critics are almost certainly correct. I don't have time to go into that other than to note that when you have Justices Scalia, Thomas, Souter, Breyer, Ginsburg, and Stevens all agreeing on something, that is, that McConnell has been effectively ignored, it is almost a law of nature that that position must be correct if those six agree on it. There are some open issues, I think, after Wisconsin Right to Life. I think a question is that will need to be decided is if an ad has two purposes, that is, it can be read both as issue advocacy and as candidate advocacy, does it stand, or are courts required to construe the ad one way or another, and then only if there is no plausible way to consider it as an issue ad as a whole may it be constitutionally fall within the scope of Section 203. But clearly, the Wisconsin Right to Life decision has certainly given people who want to run these issue ads sort of a broad safe harbor in which to construct them if they want to remain outside the scope of Section 203. Morse versus Frederick was decided the same day. This involved a case that arose from Juneau, Alaska. The Olympic torch was passing past a high school. Joe Frederick decided that it would be a really neat idea for he and his friends to unfurl a 14-foot banner that said, "Bong hits for Jesus." I know that I'm supposed to make a joke about bong hits for Jesus, but I went to college in the 70s and we took those matters rather seriously. There was a sort of an odd collection of bedfellows in the Morse case. Frederick's side, that is the side of the student, was supported by, on the one hand, left liberal groups such as the Lamba Legal Defense Fund, the American Civil Liberties Union. On the other hand, it was also supported by religious right organizations such as the Christian Society, American Center for Law and Justice, and the Alliance Defense Fund. I guess when you come up with a statement like "bong hits for Jesus," there's something in it for everyone. In Morse, a majority held that the speech was not constitutionally protected. It did so, however, in an odd way. It noted its principal precedents that in the student free speech area, that is Tinker versus Owens, in which the court was not permitted to, or the court held that a school district could not permissibly prohibit students from wearing a black armband in protest of the Vietnam War unless they had a reasonable belief that it would disrupt the educational process. But the court noted that doesn't apply here. It didn't explain why, but it doesn't apply here. It noted the precedent in Bethel School District versus Fraser, which had allowed school officials to censor or to discipline a student for engaging in a very lewd, sexually explicit and offensive talk, but noted that that doesn't apply here either. It expressly declined to permit the discipline of Frederick on the grounds that the banner was offensive. It noted its prior decision in Hazelwood versus Kuhlmeyer, which says that school officials can censor student speech in a school-sponsored expressive activity if they have legitimate pedagogical concerns, but it expressly said that that doesn't apply here either because no one could reasonably conclude that the speech was that of the school. And it adopts what those of you who, like me, are fans of the cartoon South Park will recognize as the Mr. Garrison exception. Drugs are bad. It essentially held that in this case, the school district could regulate this speech, could discipline Frederick, because in the majority's view, the banner could be read as promoting illegal drug use. The majority is careful, however, to state that it is not holding that this means that student speech that comments on a social or political issue, including the legalization of drugs or the utility of the drug war, can be constitutionally suppressed. And in fact, Justice Alito and Justice Kennedy write separately to say that they felt that they wanted to make absolutely clear that this was limited to the advocacy of illegal drug use and that this case did not warrant the suppression of commentary on political or social issues. There's a difficulty there, I think, in the sense that, two difficulties, I think. First of all, in Justice Alito's concurrence, he justifies this exception based upon concern for the physical safety of students, while making clear that it doesn't extend past drug use. But why is that the case, really? I mean, couldn't one construct a rationale that the suppression of all sorts of other types of speech is necessary to promote the physical safety of students? One of the cases that the court granted cert on, but then dismissed as improvidently granted, was a case called Harper versus Poway School District, in which a student had, on the day of silence, which is in many school districts is marked to show support for the rights of gays and lesbians.
Your time is up.
I guess it is.
Okay. Now we go.
Um,